Um, and then also the right to appeal to the MSPB, the Merit Systems Protection Board. They're a small little independent government agency, and they do adjudicate appeals from federal employees who have faced adverse actions, including removal from federal service. But only employees have the right to appeal a removal at the MSPB. There are some very, very limited rights that probationary employees have to appeal to the MSPB. It includes if the termination was based on marital status, which I don't know if I've ever heard of an actual claim of that. If it's based on pre-employment conditions, that's usually if it's something to do with like a background investigation, for example, or if the termination was based on a partisan political reason. And I have to say in the past, we have certainly not really seen that. I can't rule out that that could be applicable today. I do know, there was some folks even on something called a target list based on their, political donations, $40 here to go to a cocktail party for a Democratic candidate, that kind of thing. So if that does apply to you, then even if you are a probationary employee, you could appeal that termination to the MSPB. But other than those very, very limited exceptions, you do have to be an employee to appeal. So obviously, first you have to figure out if you're in the competitive service or accepted service. If you're confused about that at all, take a look at your SF50. Any SF50 should define if you're in the competitive service or accepted service. If you're in the competitive service, you have to do a 1-year probationary period. If you have not done 1 year in the agency you are currently working in, but you came from another agency and you have more than a year of what's called current continuous service. I'll just qualify that a little bit. More than a year of current continuous service other than a temporary appointment limited to 1 year or less. For example, even if you had a term appointment that was not to exceed 2 years or 4 years, you could count that service. So the gist is, if you're in the competitive service, if you have more than 1 year of continuous service in the federal government, you should be an employee for purposes of appealing your termination to the MSPB. If you are in the accepted service, there's a 2-year, they use the term trial period. I don't know why you'd think they could just use the same terminology to make it a little bit more clean and clear, but 2 years in the accepted service. And you can count prior service for the accepted service as well. However, if you're in the accepted service, you have to have 2 years of current continuous service in what's called the same or similar positions. And so usually we're looking at things like, the job series, the job title, the position description to see if the duties are generally the same. So the gist is competitive service, 1 year, accepted service, 2 years. The exception to the accepted service rule, I'll call it, is if you have veterans preference. If you have veterans preference, then you only have to do 1 year in the accepted service to become an employee for purposes of MSPB appeal rights. The term preference eligible is used a lot. What that means is that you have veterans preference. I don't know why they couldn't just keep it clean and say, if you have veterans preference, but that term preference eligible, if you've seen that, that's what that means. It means that you have veterans preference. So I know that there are folks who were deemed probationers because they were recently promoted, or first time in a supervisory position, that sort of thing. While the agency can have you do what they call a probationary period upon getting promoted, that does not take away your tenure as an employee. So what that means is if you were promoted from a GS 13 to a GS 14, you have to do 1 year probation as a 14. If they're finding you're failing to meet expectations in that position, they can move you back down to the GS 13 position. They cannot, however, just terminate you without due process. And if they did, you can appeal that to the MSPB. So That's really the first question I think to figure out is, are you an employee or not? I think the most complicated situations are when there's some sort of break in service. So there is something called tacking, where you can tack on prior service, so long as the break was less than 30 days. But it also has to be service in the same line of work. It has to be immediately preceding the current probationary appointment. So I'd say the notion of tacking on prior service is messier than it needs to be. But I think the easiest way to think of it is, did you have current continuous service for 1 or 2 years? If there was a break in service, there certainly are exceptions where you could still have tenure. I actually have a case right now pending before the U.S. Court of Appeals for the Federal Circuit about whether or not someone who had a short break in service and then was a direct hire had to do a new probationary period or not. These issues just are messy. But even if your new agency said you have to do a probationary period upon some new appointment, you could still be in a probationary period, but also have sufficient continuous service to qualify you to appeal to the MSPB. And so why does that matter? So at the MSPB, what they're going to look at is if you are an employee, whether you were afforded due process in your removal from federal service. If you were denied due process, then that should be automatic grounds for a reversal of that action, meaning reinstatement. And obviously, like I said, I don't think anyone has gotten due process who was terminated in this way. So if you can show to the MSPB that you're an employee, that should be grounds for the MSPB to reverse that action and reinstate you. So that's obviously a critical thing to figure out in this very situation. We're certainly doing consultations with folks who are in those slightly more complicated situations, either, because of a gap in service or a switch between competitive and accepted service and back to competitive, or a change to Schedule A even. There are certainly many situations that are complicated, and we would certainly be happy to offer a consultation with anyone who needs to figure that out. I do think that is something everyone should figure out. We are asking for folks to send us an SF50 just so we can kind of wrap our heads around how the agency has it set up. If you haven't already pulled a copy of your EOPF, I've been advising folks to do that for a few weeks, but I would certainly advise everyone to do that, just so you have it, just so if, for example, you've not yet been terminated and that does happen, you'll have those documents available, to figure out what your rights are. So, and the MSPB, just to kind of give an overview of the process, we would e-file an appeal and make the argument that you meet the definition of an employee right in that initial appeal, probably include that SF50, right along with that package. The MSPB traditionally assigns a judge within, 1, 2, 3 days. Obviously, the volume right now is tremendous. I do still think they are going to try to process these expediently, especially these ones where, we have it very plain and clear to them that this person is an employee, and reversal of this termination needs to happen. What typically we see where the due process violation is that an agency would then redo the termination, but provide the person with due process. So in other words, if someone was terminated because they were found to have committed some sort of gross misconduct, and we appealed to the MSPB and we won on sort of a due process technicality, the agency would usually reinstate the person, but put them on administrative leave and then issue the notice of proposed removal with the reason for the proposed termination, give them the right to reply, and then issue a new decision terminating them. I don't see that happening here because there is no reason for these terminations, right? I mean, this is just taking advantage of the fact that they know that you have fewer rights as a probationary employee than you do as a full employee. So I do suspect that if you are reinstated after appealing a termination and you can show you're really an employee, it probably would mean that you would actually, be able to get back to work. Obviously you could then be subject to a RIF or something like that. But if you've seen cases where there has been a reversal, undue process, and then an additional termination action, that's usually because in that case there is evidence of misconduct or unacceptable performance, not sort of what's applying to the masses right now. And I do see questions coming in. I'm certainly going to try to get to those. I'm probably going to kind of get through the main things I want to talk about, and then I'll spend whatever time is left going through these questions. So that's sort of the MSPB option, and the MSPB in our world, it moves at rapid speed compared to other processes. I don't know if anyone on here has ever filed an EO complaint, but that can oftentimes take years to get through. The MSPB has a rule to adjudicate cases within 120 days. And with this sort of thing, I wouldn't expect that it would even take that long unless they're just so bogged down with volume that it's taking that long for the judge to actually get eyes on them. The other option that became a much more viable option as of yesterday afternoon is with the Office of Special Counsel. And just so both with OSC as well as the MSPB, Trump did fire the special counsel, Hampton Dellinger. Trump also fired Kathy Harris from the MSPB. The termination of those two individuals doesn't, I'm not going to say it doesn't impact the work that those two agencies are doing, but it doesn't stop the functions of those two agencies. So if you do hear out there that the special counsel's been fired or the board's been fired, that does not mean that the judges of the MSPB aren't still adjudicating cases. They are. And that the attorneys who work at the Office of Special Counsel aren't still taking complaints. They are. Like I said, all of these entities are probably bogged down with loads of complaints and appeals, but they are still functioning even if those terminations happen. Although as of right now, both Kathy Harris and Hampton Dellinger have been reinstated, and the Supreme Court denied the Trump administration's appeal to intervene and have the lower court ruling overturned with regard to the special counsel anyway. So for now, I think we're presuming that these folks are there and these entities are functioning as they should be. But so OSC does have jurisdiction over what are called prohibited personnel practices, or PPPs. Traditionally, their bread and butter is whistleblower retaliation. That's what they're known for. That's what they do. That's what they do best. But they also do have jurisdiction over any prohibited personnel practice. The rights are slightly different with a non-whistleblower retaliation type claim, but you can file a PPP complaint there. And what happened yesterday is that they found that for 6 employees anyway, there was a prohibited personnel practice when the Trump administration fired these probationary employees for alleged performance problems when these folks had proof that their performance was outstanding. So I think, these termination letters that went out to probationers seem to be cut and paste jobs, right? I mean, the same language was used in most agencies. And within an agency, nobody got a customized letter, right? These were very much one size fits all. And so several folks have an outstanding performance appraisal issued just a couple of weeks ago, right, in your hand. So OSC said, look, if this person has record of outstanding performance. You can't just say their performance doesn't warrant their continued employment at this agency. And basically what OSC said is, this is a false, phony reason. You're alleging a performance issue to cover up the fact that this is really a RIF. And no federal agency, you need to follow RIF regulations and procedures. So procedurally, what happens is that OSC effectively stays the terminations. In other words, what's a little bit funky is that typically we're dealing with proposed adverse actions, not actual, but basically we'll put these folks back on admin leave. And then I guess within 3 days from yesterday, the MSPB will decide whether to enforce that request for a stay. And Henry Kerner, the Republican board member, has recused himself on grounds that he just most recently served as a special counsel. So it's going to be one of the two Democrats at the board who decide whether to enforce these stays that OSC granted or not. And the language of the law says, the MSPB shall enforce unless there's something really, really wrong, right? So I think, fingers crossed, we're hoping that the MSPB does agree with OSC that these stays were appropriate. And then OSC will be afforded time to further investigate this issue. I don't really know how much investigation is needed in this circumstance. In normal times, if you'd asked me 6 months ago what OSC would do, I would say that OSC would get with the agency to try to get this nipped in the bud and resolved and get this person back to work. So I sort of assume that same kind of thing will be happening. There was a class complaint filed at OSC through Democracy Freedom, which is sort of working with a bunch of firms like ours included. We're kind of sending up the chain the actions that need a TRO or injunction, and they're pushing back down to us, the MSPB appeals and OSC complaints and whatnot. But so there was a class complaint filed at OSC. There's nothing in the law that allows a class action to be filed at OSC. There is something that allows class actions at the MSPB, but not OSC. So I suspect that what we are going to have to look at is filing individual OSC complaints, which, is like I said, it's a viable option for sure. I just don't know how backlogged and jammed up they're going to be if that's the way, in essence, they've got to do it. And I do think, again, in normal times, OSC would have said, it's a prohibited personnel practice to terminate a probationer for a fake reason, and that would then have broader applicability, right? And so I don't think we know yet what's going to happen with that, if somehow there's going to be some mechanism to apply this more broadly, or if in fact all of you are going to have to go through with filing OSC complaints. OSC has always been understaffed. They just don't get the budget from Congress that they need to do the job that they're charged with doing. So they've always kind of been slow going. I know a number of attorneys have left in the past few weeks from OSC. So I'm just a little nervous that it's going to be a process that ends up kind of backlogged. But at the same time, I do think there's just been so many instances where supervisors said, I want to keep this person. This person's an outstanding performer. And if there's a way to get this person back, they want to do that. So, it's certainly a good mechanism to have that happen. And I will say this is really the first time I can ever think of where the supervisors have been cut out of these decisions. one of the first executive orders, or I guess memos that went out from OPM on one of the executive orders called for agencies to identify probationers and then identify the ones that the agencies wanted to keep. And I think agencies did that. I think they went through the, annoying and painstaking process of saying, here's all our probationers. These are the ones that are solid that we want to keep. And then nevertheless, the administration went ahead and fired folks. And I know a lot of times that was done with absolutely no coordination with the supervisor. The supervisors didn't even know it happened, which is completely crazy. But so I do think because of that, the supervisors certainly do have the authority to authorize a reinstatement. So hopefully there can be some movement by the agencies themselves versus by the, administration or DOJ or, whatever entity is mysteriously, the puppet master, so to speak, and folks can actually get back to work. There's also the option to file EEO complaints. What is tricky about EEO complaints is that it is the case that the employee has the burden of proof, and we have to show that it was an act of intentional discrimination. So just given that this was done in such a mass way, without regard, quite frankly, to almost anything, it seems it's going to be difficult for folks to establish a viable EEO claim. But there certainly can be exceptions. I can certainly see exceptions in cases where, maybe someone requested a reasonable accommodation to be able to continue to remotely work or telework, and that caused some sort of brouhaha. And then all of a sudden, there was some sort of attack on you, attack on your performance, or you just got fired. And there seems to be some sort of causal nexus between that activity of requesting the accommodation and the termination. But I do think it is, in a broader sense, probably one of the options that doesn't necessarily fit this circumstance the best, but it is an option. And I will say, just to kind of back up with the process. So at OSC, they do also have an e-file option. You can e-file a complaint, and then they are going to do an initial assessment of it. If you're going to request a stay of a termination, this is incredibly annoying and it drives everyone crazy, but they actually don't have a form for that. You have to write on the form you're requesting a stay and make that, loud and apparent. Sometimes they even get obnoxious and put it in like big, bold red letters, like request for stay, please pay attention to me. But it's a process where OSC kind of does the legwork for you. So if they do accept your case for prosecution and investigation, you kind of get to sit back. They're doing the heavy lifting. What's tricky about this particular kind of case, because it's not whistleblower retaliation, it does not come with the right to file what's called an individual right of action with the MSPB if you don't like what OSC has concluded. So I know I'm getting in the weeds here, but so traditionally you go to OSC, I'd say 90% of the time you're going to OSC because of whistleblower retaliation. If OSC either declines to take your case to prosecute it, or you just get frustrated with how long they're taking, there can be an option to get an individual right of action, and you can then take your case on your own to the MSPB. This is not going to be an option if you're just filing a prohibited personnel practice alleging you were fired for a fake reason, for example. That wouldn't matter necessarily if OSC does stay the action. I mean, really, that's what you're looking for anyway. But just to kind of, give people some idea of what to expect. With the EEO process, you have to start inside your agency. So you would contact your agency's EEO office. You have to file an informal complaint. It's usually, pretty simple form you fill out. And then the agency does what's called EEO counseling. You can also elect what's called alternative dispute resolution, ADR, mediation. It's all the same thing. Really, you try to see if you can get it resolved at the lowest level. And a lot of times we do pick that EEO option because of that opportunity to have that ADR session early, and to try to nip something in the bud, before we've got to wait for other processes to take place. I do think if your supervisor really does want you back, that could be a mechanism to get the supervisor to be able to do that. There could also be an administrative grievance even to get to that opportunity. So all agencies do have administrative grievance procedures. They're normally pretty worthless process. I mean, they don't have the threat of arbitration behind it the way a grievance filed through the union does. So normally it just goes up your chain says, rubber stamp what the person below did, and you don't get far. But in this situation where the person who decides the grievance is the person who wants you back because they did value you and value your performance, it could be a tool that enables the supervisor to justify bringing you back and sort of, coverage for that action. I do want to throw it out there as an option. Also, I'm sure several of you folks are in unions or are covered by collective bargaining agreements. I do think the unions are overwhelmed, rightfully so. There are several filing TROs for some of the the bigger issues going on in the government. Pick one, right? I mean, there's a new one every day. I do know that some unions said we just can't deal with the probationer cases, which stinks, but at least they're being upfront about it. I do know other unions are filing grievances. I'd say that one thing I've seen go wrong, I mean, make sure you know what your union's doing. So make it clear to them whether you do or don't want them to file a grievance on your behalf. I've heard of situations where the union is filing grievances on folks' behalf, and they don't even know that that's happening. And the reason that matters is because there are election of remedy issues. And so that premise of election of remedies means you can only pick one remedy. You can't file, for example, an MSPB appeal and a grievance through the union over the same thing. Same thing goes with an EO complaint. You've got to pick one, and then the one you pick is the one you get. Like I said, unions can be fantastic, but make sure you know what they're up to and make sure that they're keeping you in the loop on everything that they're doing, so that they're not inadvertently cutting off your ability to do something like file an MSPB appeal. All right, let me look at some more of these questions. All right, so someone's got a question about, there was a break in service, and then they came back. Like I said, I think that there's a credible argument you don't have to do 2 probationary periods, and there are certainly many people, when they do come back, the agencies, instead of doing a new appointment, a new initial appointment, do a reappointment, and do give folks tenure. There are other agencies that don't, and I don't even think sometimes within an agency they do it consistently. This is a problem that that shouldn't be, and I think it's just, this situation has kind of shined a light on this mess. So this is similar to the case I have pending now at the Federal Circuit, which is it's the court that's like one step down from the Supreme Court. So their decision will have broad consequences. But I think that there is plenty of justification in the federal regulations for the premise that folks don't have to do a new probationary period if they've already completed one. But for purposes of folks on this call, I want you to know that the MSPB does not agree. They do believe that you can be required to serve more than one probationary period. And the agencies are all over the place with it. So I know that there are some agencies where you come in and they say you're a probationer, and then your OPF gets forwarded. They see prior service. They then run a correction action to show that you have tenure and you've completed a probationary period. I know other agencies, when they get the OPF forwarded, they'll change the service computation date, for example, but they still say you're in a probationary period. And if you do have current continuous service, that doesn't matter. But if there is a break in service, like I said, that's where it gets tricky. And that's where, I'd be happy to consult with anyone. And what we really want to do is just look at your EOPF, put together these SF50s, see what authorities they used for your appointment, see competitive service, accepted service, and all of those things and how they fit together. But I do think that there can be a credible argument, even if there is a break in service. I just, I want folks to know that that's an issue that's more contentious than it seems like it should be, perhaps. All right, at what point does accepted service get appeal rights? Like I said, it's 2 years. And you can include prior service, but it does have to be in the same line of work. So, which is, I don't know, it's just silly, but if for the accepted service, you have to have 2 years of continuous service in the same line of work. So even if you were just in your current job for 6 months, if you've got 18 months of prior service at some other agency, you can use all of that so long as you didn't drastically change what you're doing, right? So, I mean, if you were working as like a program manager and then you were going to law school at night and then now you came back and you're an attorney, that's not the same line of work. I'm going to say that's a very rare circumstance. Most of the time, folks are doing things in the same line of work. Otherwise, they wouldn't be qualified for the job, right? All right, a question about a personal service contractor. This one looks messy. And then that they were, and you were forced to reapply to your same role as civil. I'm going to say where this one requires a consultation. There are a number of circumstances where there are these conversion mechanisms, and they're just also different. Like I know FEMA employees, a lot of them work on these like 2 or 4 year core contracts, even though they're really employees. There's just a number of mechanisms used. And I just don't want to, without digging into it further and looking at some documents, give anyone kind of a quick answer on that sort of situation. Typically time as a contractor does not count toward time as a civilian. So nor does military service. So typically what we are looking at is time as a civilian, either in the competitive service or the accepted service. I do think there can be some exceptions though, and I know personal service contractors, I know there are plenty of them at state and USAID in particular who have been impacted. Happy to like I said, have a consultation on that. There's also so I think I mentioned military service. I mean, so even if you did buy back your military time to go toward your retirement, you can't add that on to your civilian service. I mean, it's basically there for purposes of enhancing your annuity, but it doesn't lengthen your time as a civilian employee. There are also some agencies that don't have MSPB appeal rights. So if you work in the intelligence community, if you work for CIA, if you work for NSA, actually NSA might be different. So there are some DoD intelligence agencies where if you are preference eligible only, you can appeal to the MSPB. So I know DIA, NRO, I'm guessing NSA too, because I know NSA is under DoD. If you're preference eligible, you can appeal an adverse action, even if you do work at that agency. The FBI employees don't have MSPB appeal rights generally. Weirdly, TSA screeners don't have MSPB appeal rights, and it's really bizarre. They don't have MSPB appeal rights because they were established under the FAA's personnel system, but now FAA employees have MSPB appeal rights, but TSA employees still don't. It's one of those things that doesn't make any sense, but it just kind of is. VA employees, if you're Title V, you should have MSPB appeal rights. If you're Title 38, you would not. Title 38 would be folks involved in medical care, right? Direct patient care, doctors, nurses, that sort of thing. If you're hybrid, which is uniquely a VA thing, you should have MSPB appeal rights. So there certainly are agency exceptions for all of these things, and unusual circumstances. Like I said, I mean, a lot of this does have to kind of be looked at on a more case-by-case basis. For probationary employees fired without due process, would reinstatement include back pay? The answer is yes. You would be retroactively reinstated with back pay as well as back benefits. Damages are not something that the MSPB awards unless you prevail on an affirmative defense like discrimination or whistleblower retaliation or some sort of law that comes with damages. You don't get sort of general emotional distress damages for them putting you through this nightmare. I really wish folks could get damages because I know this has been absolute nightmare to live through, but the expectation would be that you would get reinstated, the removal, termination, whatever we want to call it, would be rescinded. And you would also be entitled to reimbursement of any attorney's fees. So if you hire my firm, for example, we put in a petition and the government's got to reimburse your attorney's fees. Someone who only worked for 3 weeks, geez, what a time to have walked into the government. I feel so, it's like I feel terrible for folks at the end of their career who have to kind of end their career on some of these bitter notes. And then I also feel terrible for these folks who are just starting their career and are just, it's like, what a way to kick off a career. If you didn't even have performance standards in place, I don't suspect that OSC is necessarily going to be an option based on what we've seen from them thus far. But you're mentioning the union here. I mean, I do think that the unions, how to say this? So some of the first cases they filed almost like too quickly, and the courts found that the unions didn't have what's called standing to bring the case. So in other words, they were trying to argue that the actions of the administration were harming the union as an entity, and the court was like, no, you're really talking about harming the employees, so you need to have an employee who was harmed bring the case. So obviously now the unions have that, right? They have folks who were terminated, and so any action would be brought on behalf of folks who do have harm caused by the acts of the administration. So that should skirt around those standing issues. So for folks in that kind of situation where you're so new, you haven't even had a performance assessment, I think your best bet probably is going to be through some sort of action by a union or a larger collective action on behalf of all probationers, where the act itself of firing folks with this cut and paste ridiculous letter violates law because it's a prohibited personnel practice, sort of in theory and in existence. I think that, like I said, now that there are folks with actual harm, I think the unions will be able to kind of refile, reboot things and go back into court. Although there's, so I mean, one other issue is that if there is an administrative remedy available, you usually have to take it before you can sue in court. So they're usually looking for folks probably like you, who started 3 weeks ago, who doesn't have an administrative remedy necessarily, because you kind of fall into this strange place. But in general, in the government, if you have an administrative remedy, you've got to try that first before you can sue in court. So just, suing in courts, just it is kind of fraught with these issues, which I wish it were easier, but I'd say the good news is that there are administrative remedies available for most folks out there. So hopefully that can get some folks some relief. Folks placed on admin leave. Yeah, you can't file an appeal with the MSPB until the action has been effected. So if you were told you're going to be on admin leave until March 14th, whatever, you can't appeal that action until March 15th. You actually have to wait for it to go into effect. And that's always been the case. That's always been the rule. Really the reason is that you don't have standing. You don't have an adverse action that's been affected to complain about. You actually have to be harmed to have the right to file that sort of action. That's also what drives me crazy about people saying, oh, the process drags it out and it somehow wastes government money. It's like, no one is in that process unless they're not getting paid by the government anymore. So, so give us a break on that sort of complaint. Someone said, so right now the response of the MSPB is longer than 2 to 3 days. I think, well, what a little birdie's told me is that what they're trying to do is triage cases. So what they always do, I mean, this isn't unique to right now, but what they always do is have paralegals and staff screening these appeals to figure out what they are and what bucket they go into, right? And so if it is someone who was removed for misconduct, that's going to be treated differently, I think, than someone who says, I was terminated as a probationer and here's proof I'm not. I think the smartest way to do it is to have everything right there, right? I mean, what I do is literally in the appeal form state, pursuant to the applicable law, right? The applicable section of the statute. This person is an employee, see box, whatever on the attached SF50, and just try to kind of nip this whole thing in the bud. And quite frankly, I think we can do this very efficiently because it is going to be, we're going to be doing cut and paste jobs, right? I mean, there's only so much to be said. And I do want to figure out how to do this efficiently for folks so that we can get these things in quickly for a low cost, and hopefully get these processed pretty quickly. So what traditionally happens in a case like this, if we file something and our client looks to be a probationer, is that we would get an order to show cause to establish jurisdiction. We would then have to file a brief to say, here's why this person is an employee, see, all these exhibits, tell the whole story. This person was initially appointed, then there was a break, then they went to accepted service and they came back, go through the whole thing. I think now that could happen in some circumstances. I suspect if there's ever a break in service, we're probably going to have to do a brief. But if we're just talking about current continuous service and we've got proof of that, I'm hoping we don't actually have to do the brief. If we do, this is going to be a 1 or 2 page brief. We're just going to state, here's the law, here's how we meet it. And due process was absolutely not given. Also, traditionally, if we are asserting a due process violation, the agency is given an opportunity to show that they gave due process. I think we can also cut that off by attaching the termination letter that said effective immediately, right? I mean, that shows that you were not afforded due process. So yes, they're going to be backlogged, but I do know that they are trying their best to figure out how to process these efficiently. And, it's certainly hitting the Washington regional office the hardest just because of the volume. Folks, in other regions across the country probably are a little bit lucky because they're not going to have to get in the Washington regional office line. But um, and obviously this has been happening nationwide. It's just that DC has a higher concentration of these folks. Um, but I cannot see a case where we're going to have to go all the way through the usual MSPB process, right? I mean, we're not going to have to get into discovery. We're not going to have a hearing, all those things that normally take place at the MSPB. We should be able to cut this off pretty quickly and have reinstatement ordered. I know there's been questions about whether or not the administration will honor decisions from the MSPB, OSC, EOC, what have you. That's certainly not a circumstance we've seen before. But all of those entities have mechanisms to enforce their decisions. So, for example, at the MSPB, we would file a petition for enforcement and really, have the MSPB take it up with the agency. But I doubt that's going to happen in sort of lower profile cases. I mean, I think if we're talking about Biden appointees, we're talking about some SES folks, that could be something we see. But my hunch is that for the vast majority, we're hopefully not going to run into that problem. Also, timelines for these things. Typically, you're given a decision to remove you from federal service that sets out all your rights. And I think because they said these were all probationers, even if you were not a probationer, you got the rights for the probationers. But what I tell people is for the MSPB, you've got 30 days to file an appeal from the date the termination became effective. You don't have to wait that long, but I'd say ideally you do it within that time frame. For the EOC, you have to make contact with an EO counselor within 45 days. OSC does not have a statute of limitations issue. We can always go to OSC. Obviously, we can't, if we wait like 6 years, they're going to say, give me a break. But, if we go in 33 days, they're not going to kick us out. However, even at the MSPB, I think if somehow it's day 33, we can argue that you weren't properly notified of your rights, thus, because you were denied due process, and the timeliness should be waived. But ideally, we do get these in sooner rather than later. All right, I see that I think I literally have 58 messages, which I know there's no way I can get through in 10 minutes. So and I think some of these I've hopefully already answered. But and it's funny, I can see some people chiming in to answer each other's questions. I'm glad there's, it is nice to see folks coming together. I mean, I do there's sort of one silver lining in this is kind of seeing how people are pulling together and wanting to do things like class actions and collective actions because they are concerned about how their coworkers were treated as well. Yeah, sorry, I keep looking at these questions. I really do wish I could answer more of them. But like I said, we certainly are available to set up consultations with folks. We are offering either a 30-minute consultation for $200 or a full hour consultation for 400 hours. And I'm also happy to look at folks' SF50s just in a quick 5 minutes to let you know if it makes sense or not. Or if you do have, if I can look at your SF50 and I can tell that you clearly have tenure, I don't even think we need to go through all of that. We could just send you a representation agreement. And then of course, I think we also need to decide in each situation, does it make more sense to go to the MSPB or OSC or some other avenue? But I do, and I feel like every time I say something, then the administration does something new. But I mean, my hunch is that we're still likely to have an opportunity for the quickest result at the MSPB, in part because of the announcement yesterday. I suspect they're already just flooded with these. And I know my personal friends who worked at OSC in the beginning of January no longer work there. So I know they've lost several investigators, several folks who prosecuted these cases. So they're not going to be able to fill those positions either. So I, I I suspect OSC is going to be pretty bogged down. What I'm really, really hoping for is that there is some sort of larger holding that can be issued, even if it's by an entity like the MSPB that says, anyone who can prove that they they were a successful performer, do so through this mechanism, and you should be reinstated, or just even calling the whole thing off, because everyone knows that those were cut and paste fake letters that went out that didn't really address what was actually happening, right? I think everyone knows those were a quick and dirty way to try to do a riff. And so hopefully some entity says, no, agencies, you got to actually do a riff. You can't just do it this way. And that benefits all of you. Um, but we're happy to consult with people, happy to take these cases on. Like I said, I think we'll really be able to streamline them. We do typically do this work on an hourly basis. I mean, I think that we're probably going to be able to do these really rather concisely, because um, we know the arguments we're going to be making. We're going to have already looked at your SF50s. We're going to be able to put together the appeal in not that much time and get that off. And hopefully that's really all we need to do. Like I said, I do think there's going to be some cases where you have to do some briefing, but not much. Same thing with OSC. What we would do would be to prepare the complaint, which is not rocket science. Our paralegals can do this work, and then we'd be sending that off with your performance appraisal, showing that the reason for the termination was fake, and then OSC hopefully will intervene. Um, so I do think there are viable options, which is the good news. And we're happy to help as many folks as we can. Like I said, I think with streamlining all of these processes, we're hopefully going to be able to do this in a way that's really affordable for folks. And like I said, attorneys' fees are part of the relief that you're entitled to. So if we do have to spend an hour of attorney time on this, we should be able to get that back really readily. I know that obviously if you've been terminated, finances are a consideration. I really, I just think we can likely find a solution in the vast majority of cases. Um, so I can also try to follow up with these questions. I know my staff's on this call, and I'm sure they're recording everyone's questions, so we can try to figure out how to address them all. Um, but thank you all for joining. I really hope we can help. I personally feel just terrible about what's happened to all of you, and I mean, it's really just tragic that you're being treated this way after the contribution you've all made to our country, and the service you've given. And hopefully, that the work you were doing was valuable, and that it was important work, and you're not just disposable. I think that's part of one of the grossest aspects of this is just treating employees like they could disappear tomorrow and it doesn't matter, it doesn't impact anyone. I think we all know that that's not true. I suspect all of your supervisors know that's not true, and most would welcome you back. So I will end this now, but thank you all for joining, and we're certainly available for further consultation, or to file MSPB appeals or OSC complaints, or whatever makes sense in your situation. All right, take care, everyone.